All right, thank you all very much. I first want to remind you that this panel is being recorded and your attendance here is consent to use of your appearance in connection with this event. Our second panel is titled Post-Ratification History and Liquidation. One of the most salient debates in originalist jurisprudence is the validity of post-ratification history as a tool in clarifying the original meaning of a constitutional provision. For years, originalist scholars have debated what history can and should be used to interpret the Constitution, with particular concern over the validity of post-ratification history. Should interpreters of the Constitution use post-ratification history to discern the original meaning of a provision? If so, what history is fair game? Could the normalization of post-ratification liquidation better enable compromise over constitutional meaning? To help answer these questions, we have another panel of three outstanding professors. The panel is going to be moderated by UVA 1L and member of the Symposium Committee, Thomas Ross, who will introduce our speakers. Please join me in welcoming our panelists.
Good morning. It is my esteemed honor to introduce our panelists for today's panel. Professor Robert Leider is an assistant professor of law at George Mason University's Antonin Scalia School of Law, where he teaches criminal law and torts. His scholarly interests are in criminal law, criminal procedure, and constitutional law, especially concerning questions about the use of force and the rule of law. He has written on the law of self-defense, the constitutional allocation of military power, and gun control. Before joining Scalia Law, Professor Leider worked in private practice and was an Olin Cyril Smith Fellow at the University of Pennsylvania Carey Law School. He clerked for Judge Diane S. Sykes on the Seventh Circuit and Justice Clarence Thomas. Professor Leider earned his bachelor's degree from George Washington University, a JD from Yale Law School, and a PhD in philosophy from Georgetown University. And while at Yale, he served as an articles editor for the Yale Law Review. Professor Joy Milligan is the Martha Lubin Karst and Bruce A. Karst Bicentennial Professor of Law at the University of Virginia School of Law, where she teaches courses in civil procedure and civil rights law. Her research studies the intersection of law and inequality with a particular focus on race-based economic inequality. She's currently studying legal and political struggles over federal administrators' long-term role in extending racial segregation. Before entering academia, Milligan practiced civil rights law at the NAACP Legal Defense and Education Fund, where she was a Skadden Fellow and clerked for Judge A. Wallace Tashima on the Ninth Circuit. She's a graduate of NYU School of Law and earned a PhD in jurisprudence and social policy from the University of California at Berkeley with a focus on race, politics, and legal history. She also holds an MPA from Princeton University and a Bachelor's of Arts in Social Studies magna cum laude from Harvard-Radcliffe. Lastly, Professor Aditya Bamzai is the Martha Lubin Karst and Bruce A. Karst Bicentennial Professor of Law at the University of Virginia School of Law, where he teaches courses in administrative law and computer crime. His research interests in the field of civil procedure, administrative law, federal courts, national security law, and computer crime. Before entering the academy, Professor Bamzai served as an attorney advisor in the Office of Legal Counsel at the U.S. Department of Justice and as an appellant attorney in both private practice and for the DOJ's National Security Division. A graduate of Yale University and the University of Chicago Law School, he served as a law clerk to Judge Jeffrey Sutton on the Sixth Circuit and Justice Antonin Scalia. Just this spring, he was awarded the Federalist Society's Joseph Story Award, which is awarded to an academic who has demonstrated excellence in legal scholarship, commitment to teaching, a concern for students, and who has made a significant public impact in a manner that advances the rule of law in a free society. As with last panel, we'll start with 15 minutes from each speaker, then some time in conversation, and then questions. So first, to Professor Leider.
All right, thank you, Thomas, for the introduction, and thank you to the UVA Federalist Society for inviting me to be here. So in District of Columbia versus Heller, the Supreme Court held that the Second Amendment was an individual right to keep and bear arms for purposes of self-defense. Some have lauded the opinion as the most originalist in recent Supreme Court history. And whether you agree with that or not, I think I have a more nuanced understanding of what that opinion actually does. Parts of the opinion, I think, do reflect originalism and a search for original public meaning. But other parts of the opinion, I will argue, reflect the ideas of expoundment and constitutional liquidation. And I will give an argument for why expoundment and liquidation are important complements to a retrospective search for original public meaning. So in finding that the Second Amendment secures an individual right, Justice Scalia's majority opinion employs at least three modalities of argument. It begins with a linguistic analysis, and Justice Scalia, ever the student of language, atomistically inquires into the linguistic meaning of various phrases, such as right of the people, keep and bear arms, and well-regulated militia. Second, and intertwined with the linguistic analysis, is a pre-constitutional historical analysis. The Second Amendment, Justice Scalia concludes, codified a pre-existing right, a right that could trace its lineage to the right of Protestants to have arms in the English Bill of Rights. And so naturally, Justice Scalia looked to English history between the English Civil Wars and the Glorious Revolution to inform the meaning of the English right, which in turn he thought would shed light on the analogous provisions that were in the state and federal constitutions in America. But third, and most controversially for an originalist, Justice Scalia looked to post-ratification history. He examined state constitutions between 1789 and 1820 and to the 19th century state case law that interpreted the right to bear arms either under these provisions or under the Second Amendment, which at the time they treated as equivalently protecting the same pre-existing right. And he looked to how the right to arms was viewed at the ratification of the 14th Amendment and in the immediate decades that followed. Now, in a footnote in his dissenting opinion, Justice Stevens disparaged the reliance on post-enactment commentary and on the Reconstruction era history as having, quote, the same characteristics as post-enactment legislative history, which is generally viewed as the least reliable source of authority for ascertaining the intent of any provision's drafters. Against this charge, Justice Scalia responded that he was examining these sources, quote, to determine the public understanding of a legal text in the period after its enactment or ratification, which he said is a critical tool of constitutional interpretation. In this response, I think Justice Scalia sold himself short. True enough, looking at the post-enactment history might shed some light on what the original public meaning of the provisions was. But many of these sources are of questionable value in determining original public meaning in 1791. They were written decades later by individuals who were unconnected with the framing generation. And I think something else was at work in his examination of this history. Now, the court's job in Heller was to do more than to opine on the grand and abstract question whether the Second Amendment was an individual right. It also had to decide the case in front of it. And that case was whether the Constitution guaranteed to this litigant the right to keep and bear a loaded handgun in his home for personal self-defense against crime. And that is much more specific than the abstract question the court spent most of its time answering. And correlatively, the post-ratification history, I think, was not merely valuable because it confirmed the linguistic usage that a right vested in the people was not limited to members of an enrolled and organized and drilling militia. The post-ratification history was relevant, I think, because it assisted the court in operationalizing the legal right that was in the case. As James Madison stated in Federalist 37, quote, all new laws, though penned with the greatest technical skill and passed on the fullest and most mature deliberation, are considered as more or less obscure and equivocal until their meaning be liquidated and ascertained by a series of particular discussions and adjudications. This ambiguity and vagueness have many sources. Some relate to the imprecision of language. As Hart's famous example of no vehicles in the park illustrates, most laws have a core of intended meaning and a range of ambiguous applications. It is also difficult for legislators to foresee new developments in society. Legal drafting introduces other complexities. Laws must give action guidance, and yet they also have to be understandable. And these two goals often collide. In requiring that cars shall drive on the right side of the road, a legislature could likely not enumerate every circumstance in which that general rule shall not apply and exactly what actions a driver should take in the various circumstances in which compliance with the rule is not possible. So legislatures declare general rules or set standards, but often leave specific applications indeterminate. And this issue is particularly acute in constitutional cases. Just before Chief Justice Marshall famously reminded us that we must never forget that it is a Constitution we are expounding, he explained that a fully fleshed out Constitution would partake of the prolixity of a legal code and could scarcely be embraced by the human mind. The Constitution sets forth general rules. The First Amendment provides that Congress shall not abridge the freedom of speech. It says nothing of obscenity, libel, or incitement to criminal activity. And so here I think adjudication and practice are the activities that put the meat on bare legal bones. When we interpret the Constitution, we often look backward to adjudication and practice that predate its adoption. How do we know that a criminal jury consists of 12 persons who must unanimously find a verdict? Because that has been the settled custom at the time of the adoption of the Constitution. It had not always been this way, nor had juries always had to render unanimous verdicts. But somewhere in the 14th century, petit juries became fixed at 12, and they had to reach their decision unanimously. And that practice went unbroken for centuries at the time the Constitution was adopted. And it stayed unbroken until we messed it up in the 20th century. So the codification of trial by jury in the Constitution was simply an affirmation of the customary law. And so too with so many other constitutional provisions, like those granting members of Congress privilege from arrest, except in cases of treason, felony, or breach of the peace, or preserving the writ of habeas corpus. To understand the legal text, you have to know the customs, and the customs are defined by long-standing historical practice. And I should pause and note here that the inquiry I am describing is a fundamentally legal one. In the introduction to his commentaries, Blackstone asks, how are these customs or maxims to be known, and by whom is their validity to be determined? And his answer is that it is the purview of the judges who are learned in the law. And why judges? Because they learn the customs from experience and study, the study of precedents, and of learned treatises, which contain settled and first principles, perhaps based on cases that are lost to history. And I think the kind of historical inquiry that we are talking about is not the purview of academic historians. Historians answer different questions. A legal historian would ask, for example, what are the economic, social, and political forces that brought these customs into being or led to their evolution over time? What social or religious forces caused the jury to get fixed at 12 persons? Why did England replace trial by ordeal with trial by jury? But as Steve Sachs and Will Bode have explained, a lawyer's use of history is instrumental. We are seeking to understand the law, not necessarily how the law came to be, except perhaps to the extent that it illuminates what the law is. This brings me at last to my comments on post-ratification history and liquidation. Why should someone who is committed to originalism look to practice that predates the adoption of the provision? And my answer to this is because at some point, the law that was settled when a legal provision that was adopted runs out. The settled law may run out because the provision is new, and unlike trial by jury, doesn't codify a long and settled custom on which we have hundreds of years of adjudication. Or the settled law may run out because the case involves a zone of linguistic ambiguity, or it may run out because a case involves novel facts or circumstances, or because society has changed in some way. And when the settled law runs out, judges and legislators are called to create new precedents. And I think they do this through a combination of analogizing from old precedents and by employing first principles reasoning, which draws from the text and the purpose of the provision and other legal maxims. And so to answer, Professor Harrison's categories from the last panel, I think what they are doing is some version of his first and second things, that where the law is settled, the custom is a body of rules. And where the law is not settled, they go back to first principles and generate new rules from those principles. And I don't take any sides in the terminological battles, but I think this is what Randy Barnett means by construction as opposed to interpretation. Others may use the terms expoundment and liquidation. And through this process, the law develops. The common law judges who first recognized the law of defamation had no knowledge of television, Twitter, and YouTube. Is a defamatory comment made on live television or on YouTube governed by the law of slander or the law of libel? This was for modern judges to expound by using traditional legal principles. Now, in some cases, a legal provision may be deeply ambiguous and disputed. And for these provisions, liquidation occurs when a consensus develops around expounded precedents, a consensus in which the dissent acquiesces. So as in his article on Madisonian liquidation, Will Bode gives the example of Madison's eventual acquiescence to the Bank of the United States. On the military law subjects on which I write, another early example involved these forces that were known as the war volunteers. The strict letter of the law only recognized two species of military land forces, armies and militia. And when the framers used the term armies, what they meant were regular forces, those whose primary occupation was warfare. And these individuals volunteered to serve, usually for long periods of time in which they were on continual active duty. And as volunteer professionals, soldiers in the regular army could be used for offensive or defensive wars. They could be used at home or abroad. And these regular forces stood in contrast to the militia. Militiamen were civilians. They had civilian occupations, and in wartime they would perform ad hoc military service, and in peacetime maybe they would train on an occasional basis. And these non-professional citizen soldiers were often conscripted, and thus were subject to a totally different legal regime. They could only be called into active service for defensive conflicts to suppress insurrections or repel invasions, and they were not deployable abroad. During America's early wars, beginning with the quasi-war with France, a tremendous dispute developed over bills to authorize the federal government to employ war volunteers. And they were somewhere between regular forces and militia. Like militia, they were non-professional citizen soldiers brought into temporary military service for wartime. Like regular forces, they volunteered for service. They were neither fish nor fowl, and the question was whether they were governed by the provisions authorizing the United States to raise armies or the constitutional restrictions on the militia. Federalists argued they were part of the armies. Democratic Republicans countered that they were the militia, and the issue was hotly disputed for decades, and Congress reversed itself several times. But eventually, when the Democratic Republicans started treating them as part of the armies, Justice Story thought that the issue had liquidated because, quote, it exhibited the decided change of the public opinion on the subject, and the law was approved under the auspices of the very party which had inculcated an opposite opinion. And so expounded and liquidated precedent becomes part of our law, and it remains part of our law unless it's later repudiated for being manifestly erroneous. Bruin, too, heavily relies on expoundment and liquidation to determine the scope of the right to bear arms. Much of the opinion looks at early American decisions in American courts and found that those precedents generally recognized some right to carry arms outside the home. These precedents recognized that the right to bear arms could be regulated for public safety, and in America, the most common regulation consisted of laws prohibiting the carrying of concealed weapons. But courts invalidated restrictions that amounted to a total destruction of the right, such as a prohibition on all public carry. And Bruin then applied these settled principles to New York's proper clause law, which generally prohibited public carry by most citizens since they could not prove special danger. I have more to say on how expoundment occurs. I may have to defer this to the discussion period. In the Second Amendment space, I think one key fact hampering expoundment today is the lack of consensus about why the Second Amendment is important in modern times. The Supreme Court has held that the amendment is important because it facilitates self-defense against crime. It has remained ambiguous whether it also has relevance for collective defense and military-related purposes. Answering these first principle questions is an essential precondition to resolving modern disputes over assault weapons, large capacity magazines, and the like. A right that protects only personal self-defense against crime will have a different scope from a right that also preserves a well-regulated militia and collective defense. I will end with one final caution. One should not confuse reliance on post-ratification history and liquidation with evolving constitutionalism. The license here is for judges to expound the law, not to change the underlying legal principles themselves. This is the difference between a judge holding that the law of libel applies to YouTube because it's recorded in a fixed form, and a court that replaces contributory negligence with comparative negligence because it thinks it is good policy. The first is the proper purview of the court, not the second.
Thank you. Next, Professor Milligan.
It's totally up to you. Yeah. We'll switch the
All
order. if
right.
it's all right with you.
Next,
I'll just
Professor
go,
Bamzai.
I'll just go ahead. All right. Well, thanks to the organizers for including me on this panel. I don't usually think all that deeply. I hope this is not going to give my students like some sort of concerns about my capabilities, because I don't think all that deeply about questions of constitutional theory. And so preparing for the panel allowed me to review the literature and underlying sources in this area and to try to put into my own words my own thoughts on how this topic might be approached. So these thoughts are going to sound a little bit tentative. Forgive me for that. But they're my efforts to think through some of the broader themes in this area. So the idea that post-ratification history is relevant to constitutional interpretation is an old one. Famously, in many cases, as Professor Leider pointed out, but McCulloch versus Maryland, which was decided in 1819, the Supreme Court addressed the constitutionality of the Second Bank of the United States and whether the bank could assert a form of intergovernmental immunity from state taxation. And at an earlier time, when the first Bank of the United States was being debated in Congress during the 18th century, various political actors, including Representative James Madison, believed that the bank charter would be unconstitutional. Their views at that time did not prevail on the issue. And then by the time the second bank was being chartered in 1816, President Madison, then President Madison, explained that he would not veto the bill chartering the bank on constitutional grounds, in part because of the passage of time and the practice that had emerged. In McCulloch, the court held that the second bank was constitutional, in part on the ground that the practice of the government from the first Congress to 1819 should have considerable weight in resolving a doubtful question, like the constitutionality of the bank. Of course, then, if we were to fast forward about a decade and a half from McCulloch, President Andrew Jackson vetoed the recharter of the Second Bank of the United States, relying in part on constitutional grounds, and while not objecting to the use of post-ratification practice generally, at a minimum, deciding that it didn't govern in that particular case. So, the reliance on post-ratification practice in McCulloch and elsewhere it raises a couple of different conceptual issues. First, what's the reason, and these were alluded to by Professor Leider, what's the reason that post-ratification anything matters to interpretation of a written constitution? You might ask that question. And then second, assuming that post-ratification history matters, why do the views of political actors who could be motivated by all kinds of different reasons, some constitutional, some principled, some crassly political, why do those views matter? And then we also might ask, third, what do we make of the fact that constitutional issues of such political salience, such importance, can really be disputed over the course of decades? If you think about the Representative Madison, President Madison President Jackson, hypothetical in the Bank of the United States. All right, so then there are a couple of different potential responses to these issues. Some of them sound in arguments that might be broadly construed as functionalist. One is that the use of post-ratification history allows meaning to settle over time, introduce some element of predictability in the task of constitutional interpretation. Another could be about the proximity of some of these interpreters to the writing of the written document. So perhaps they just have a better sense of what that document might have meant than we have over the passage of time in a couple hundred years. Still another could be based in part on the paucity of other forms of evidence. And here I pulled a book from my old professor, David Curry, who pointed out that before 1800, nearly all constitutional law was made by Congress and the president. And in this sense, it could be said, and these are his words, that the first Congress was a sort of continuing constitutional convention. And this rationale, this is not the words of Professor Curry, but my own little gloss on it, has the air of this famous answer that was given by the British mountaineer George Mallory when asked why he wanted to climb Mount Everest, and he responded, because it's there. And so, that could be still an answer about like why to rely on these types of sources. So then the arguments that sound maybe in a more formalist tenor can depend on the idea that the Constitution itself is adopted against the backdrop of a set of interpretive principles. And among those interpretive principles are canons or principles of interpretation that you can find in old sources that say that usage is a good interpreter of laws. So usage was understood to be a good interpreter of laws before the Constitution's written. These would be statutes, or even if we think of contractual interpretation, and we have course of conduct, that can sometimes be used to understand the meaning of a contract that's written before the course of conduct develops for reasons that are kind of self-evident. And the idea would be that the Constitution's adopted at a time when those are the interpretive principles, and so they get baked into the Constitution, even though they're not said into, they're not stated in the document in so many words. That could mean that the meaning settles over time through this usage and through appropriate practices, including by political actors, which doesn't resolve the difficulty that I previously highlighted, that difficulty being that how do we pin down practices and under what circumstances do they matter? After all, as previously discussed, we have Representative Madison, who has one view on the bank. President James Madison later on has another view, and President Jackson has still another view on the constitutionality of this that question. So on this point, I'm not sure that there is and can be ever given a mechanical answer, but some scholars have tried to add more rigor to the methodology, and that brings me around to a few papers that I reviewed in preparation for this panel, and especially to the word liquidation, which potentially people on the prior panel today talked about, which at least to me, if I hadn't reviewed the papers, would have been a little bit of a mystery. But it's in the panel title, so I thought that I would talk about that for just a few moments. And it so happens that one really foundational and important paper in this area is a paper that was written by our colleague, Professor Caleb Nelson, which is called Originalism in Interpretive Conventions. And I want to say it was written about 2 decades ago, 2004, that time frame. The paper is sort of the most modern, the modern treatment that reintroduces this terminology of liquidation, which was used at the time period by various people, most prominently by James Madison, who writes about how the Constitution's meaning can be liquidated and settled over practice. So Professor Nelson's article is an article that's showing how this term was something that predated in the letters that are written by Madison and was being used by various scholars in linguistics in the theory of language in trying to explain how meaning can be given to language over time. So this it's kind of an interesting insight into what people are reading at that time period that Madison is getting this term from some other folks who are writing about those more technical concepts. All right, so that I think is the genesis of the term. And I myself have never quite really tried, and I'm not sure if there's any. I don't really know if there's any real daylight between various concepts that all seem to be based on. I'd be curious to know if other people feel differently on the idea that historical post-ratification history can matter. So that reliance on post-ratification history, some people use the term gloss or historical gloss. Some people use this term liquidation. And it all seems to be of a piece to me in the sense that it's giving weight to these post-ratification practices, whether those terms ought to be distinguished from one another. I'd be very curious to know if people have views on that. I myself sort of like look at them as all kind of in the same genre and maybe really conveying the same point using different terminology. All right, so then more recently, I looked, there's an article by Professor Will Bode that is called Constitutional Liquidation, and it's adding to this move that Professor Nelson made in his article a few decades ago, and I think that this might be an article that is supportive of this general methodology, and tries to then pin down a little bit more, perhaps precisely, when in fact the rules of liquidation might apply, when they would not. But I think, not criticism, but I think that, again, one wouldn't get a mechanical answer from the article itself, though Professor Bode points out that what one would look for in order to apply this methodology is, first things, a textual indeterminacy in the provision. That stands to reason. If the text itself speaks directly to a point, then I think most interpreters would say, well, that's just the way in which we would understand this language. So there's textual indeterminacy. Clear provisions aren't the type that really are subject to liquidation. And then there must be this course of deliberative practice. So that's kind of interesting that I guess he's reading into the sources that there should be some sort of course as opposed to potentially like a single episode. And so that's one way in which he tries to make the methodology a little bit more robust. And then finally, the course of practice has to result in a constitutional settlement marked by the notion that there's acquiescence by the dissenting side and some sort of public sanction, which you might think of as a popular ratification. So that's tricky, and just the example of the Bank of the United States shows that in some ways the dissenting side never goes away. Like there's always a set of dissenters, and what exactly do we mean by the dissenting side? Because we might say the dissenting side goes away in some disputes in a prominent sense, but in a country of like a couple 100 million, we might always find dissenters who just never go away. All right, so I think that is sort of in a broad brush like an article that's trying to advance this methodological approach and adding some additional robustness to it with these additional concepts, which still, in application just pose some difficulties. Then I looked, there's an article that recently came out by Professor Sharif Girgis, and his article is called Living Traditionalism. And as the title of the article suggests, I don't think it's wholly critical of the use of post-ratification history, but it's somewhat critical, I think, of this practice. And the way in which you might describe the practice, the article as being critical, is that there's a concern that if in fact the court gives some sort of weight to these type of practices and then gives full stare decisis weight to these living traditionalist, in the words of Professor Girgis, cases, then political practices can work as a ratchet in a particular direction. And so he highlights this point, and it might move the law in one direction, in favor or against a right, not the other, because in fact, just in the point of time when a case is being decided, the political practice points in one direction or the other. Who knows what the future holds and where the political practice would have gone after that. So in a broad brush, I think that's the concern. I don't think the article doesn't say necessarily that there's a the post-ratification practices are out of ought not to be considered, but rather that there can be concerns with their usage. Finally, I think what I would just point out is that what's sort of interesting here is that from my own perspective as somebody who teaches administrative law and not constitutional law, I run into doctrines in my own class where we do have various interpretive regimes that take into account views of political actors. And so in the area of statutory interpretation, you might think of those as being reliance on legislative history, which would be reliance on political actors in Congress, or most associated with administrative law would be reliance on interpretations put forward by administrative agencies, the famous Chevron doctrine. And so you might think of that as being reliance on executive branch actors. And those doctrines are similar in some ways to this whole notion that post-ratification history might be relevant, but they seem different in others because, it's related to some of what I've just said, but they seem different in the sense that the way in which the Chevron doctrine, as currently articulated, works, it relies on administrative agencies' positions, notwithstanding that changes might occur over time, and it doesn't really necessarily put weight on, say, sort of early administrative agency positions or administrative agency positions that are established over time. So I think that there's some similarities, some differences in how that works. And I guess, the thought that I have that I might leave you with is what's the justification for the differences? Why does that make sense? And I'll stop right there and allow my colleague to see if she has any reactions or thoughts of her own.
Awesome. Thank you so much. It's great to get to be on this panel today and learn from my fellow panelists. I think it made sense in my conversations with Professor Bamzai earlier for me to follow him because in some ways I'm relying on some of the discussion that he provided and exposition of sort of the state of the literature and particularly the concept of liquidation. I think it also makes sense because in some ways I'm probably the least sympathetic or at least have some looming questions about liquidation generally. So I find this concept of liquidation and the use of post-ratification history to be intriguing, but also somewhat mystifying as a concept. And that's not because I'm necessarily opposed to the use of post-ratification history as a general matter, but rather because the bases on which the concept of liquidation is justified and applied are puzzling to me. Some of these are simply because of my own disquiet with the basic normative underpinnings for any methodologies that fix us to a deeply undemocratic, really an authoritarian American past. And I'll say more about that in a bit. And so to the extent liquidation is a cousin, sometimes a perhaps controversial cousin, to originalist methodologies, I see it as potentially problematic for reasons that sound in the specifics of American history. Some of the other puzzles that I have concerning the idea of liquidation are more in attempting to understand it on its own terms, as its justifications, as well as the scope and limits of the concept. But to fully show my cards from the start, I'll begin by explaining what I find most mystifying and normatively problematic about the idea of liquidation from my own philosophical priors. Before turning to the narrower problems that liquidation seems to raise, even on its own terms, and for those sympathetic to it. So working from the Will Bode definition in that 2019 piece that kind of laid forth and elaborated the basic kind of framework of liquidation as he derived it and extended it from Madison, first I want to look at kind of that temporal sequence of how liquidation is supposed to unfold and over what periods. So according to that theory, as Professor Bamzai explained, in instances where there's an ambiguous constitutional text, at some moment following sustained debates and historical practice, and ultimately something near to, if never achieving, broad consensus, we've fixed and determined the text's meaning. And supposedly, this liquidation process or practice, which was, as noted, foreseen by Madison and others, embraced by Chief Justice Marshall, is evidence in particular episodes like the one that Professor Bamzai described in the case of Madison's various stances and others towards the Bank of the United States. For me, however, whether it's liquidation or originalism, I find deeply mystifying any claim that we can find legitimate constitutional meaning by looking backwards to periods when America was not a democracy as we now understand that term. So on my perspective, it's difficult to legitimate the text itself, including both the 1789 Constitution and most of its amendments, through any kind of sincere claim about popular sovereignty. The United States was not what we now consider democratic until late in the 20th century. We might call it authoritarian insofar as most of the population was excluded from political participation through 1920, and significant parts of the country remained authoritarian until at least the 1960s, in ways that in turn configured national governments in very, very deep and fundamental ways. So to me, the text itself is hard to legitimate, given that backdrop of procedural and substantive exclusion in which the interests of women and people of color were not represented in constitutional drafting and ratification. From that perspective, legitimating or even legitimately interpreting our Constitution, given its problematic origins, simply can't be done successfully by any method that attempts to fix the text meaning according to the practices of the minority who were politically empowered in those past periods. If that's true as to originalism, then it also seems to me to be true for a concept like liquidation. Liquidation may allow ambiguity in the constitutional text to persist longer and to be resolved by practices that pull in a greater number of actors, such as officials in legislative and executive positions, and even the broader electorate, such as it was, thus widening the scope of who can participate in constitutional interpretation. For some, that renders it more attractive, possibly improving on some of the flaws of an exclusively originalist practice, and Bode makes this point explicitly. But if liquidation references back to a past in which only a minority of the population could take part in most of these historic practices that serve as evidence of constitutional meaning, if claims about the values of a, quote, public, which supposedly endorses one meaning, necessarily rest on evidence drawn from a political sphere and institutions that excluded women and people of color, well, then there's nothing especially redeeming or democratic about liquidation as compared to originalism itself. Thus, if liquidation claims to resolve and fix meaning of the Constitution at particular moments of constitutional settlement, then so long as the United States remains deeply undemocratic at those moments in time, I see very little normative reason to adopt such settlements. Will Bode justify such settlements as reflecting sort of broadening their normative allure by reflecting also broadly shared values like departmentalism and tradition? But again, given the specifics of American history, values like departmentalism and tradition can't be read in the abstract, even if I were inclined to embrace either of them in that kind of abstract general sense. As much as I might believe in legislative and executive participation in constitutional interpretation as affirmatively good things, I'm not necessarily satisfied by looking to exclusionary and non-democratic Congresses and presidential administrations that we know governed us until at least mid-20th century. So departmentalism of that form holds relatively thin allure for me. Tradition also anchors us to an undemocratic past, and it cannot bear the weight of the supposed virtues it offers. When we look to tradition, if the court's precedent is any guide, we look to the views of the empowered political minority, not the views of those excluded from politics. For those and other reasons, including the reasons that academic historians, for instance, would look to, such as the historical and social the social and political forces that create custom, that explain how it came to be, often not according to particularly democratic or egalitarian modes of public life. There's no sense in which I think tradition really has democratic indicia or any guarantee that it's been endorsed by any real version of the full public. So that represents my basic stance on liquidation, again, from my own philosophical priors. But I also have some questions about liquidation on its own terms, as attempting to kind of assume a more sympathetic stance to the idea. First, I think as was already touched upon, the concept's reach seems unclear to me. In practice, it seems more confined than its theoretical breadth would suggest. Liquidation, it appears from the state of the literature, is most likely to produce answers when we consider problems of constitutional structure, i.e. the separation of powers and federalism. Both suggest that the concept could apply to rights, but gives limited examples, and other commentators have explicitly limited the concept as not applying to rights claims. And perhaps this structural focus is because we think that those particular structural constitutional provisions are either especially indeterminate and or because we think problems of institutional power have a pragmatic cast to them, such that testing a particular allocation of power over time is a good way to see if it is sustainable and not dangerous to other values, such that we might kind of incorporate it into collective experience and wisdom. But the rights provisions of the Constitution are in fact quite indeterminate also. And we've also often learned a great deal from the practical application of rights over time, such that we see in practice the reality, the lived reality of those rights' meaning differs from what many might have thought to be true initially. I think the problem may be that some of the most widely embraced rights protections of the Constitution are in fact ones that were upheld robustly via judicial review only in the 20th century. And that in fact the nation's prior long-term historical practices, indeed its prior settlements, have often been at odds with what we take to be the best current view of rights. So to be more concrete, no one, I think, has argued at any recent point that the comprehensive racially oppressive set of practices that are often labeled Jim Crow somehow liquidated the ambiguous meaning of the 14th Amendment, even though I think we could probably find the conditions that are said to be necessary for liquidation to hold true under Bode's definition. Certainly, those practices were repeated and constitutionally justified in explicit terms, and they were acquiesced to by at least the political majority of the country, including those who once opposed them. In fact, if anything, in order to arrive at Brown and its progeny, I think we unliquidated the meaning of the 14th Amendment, or rather the long civil rights movement did so in the second half of the 20th century, and that it was activism that overhauled the meaning of the 14th Amendment, affirmatively undoing the prior settlement and eventually creating a new one. I should say, just kind of as a bracketed point there, I don't buy arguments that in fact there was a fixed original meaning of the 14th Amendment that underlies and justifies Brown. I think that's an unconvincing argument on originalism's own terms. To continue, liquidation's attraction appears to be its claim to lead towards some level of fixedness and certainty, even while allowing for a certain amount of constrained evolution in meaning. If we can liquidate and then unliquidate constitutional meaning, and do so repeatedly over time, at least as that 14th Amendment example suggests, then it hardly means anything more than a version of evolutionary constitutional change, similar to Bruce Ackerman's Constitutional Moments, or perhaps even just a living constitutionalism, or descriptive political science that acknowledges that social movements affect the composition of the court and thus shift interpretation over time. So perhaps then we don't see liquidation applied to most rights provisions because the theory simply doesn't apply with a normatively compelling and descriptively accurate view of how we actually arrive at defensible constitutional meaning in that sphere. So I think liquidation is unclear in its scope and also in its claims about when it becomes fixed. As I noted, it raises questions about how we unliquidate once fixed constitutional meaning, apart from formal constitutional amendment. If we can do so, if we can in fact do that on liquidation, what is the point of the theory? How does it differ from more evolutionary theories of constitutional meaning? And if we can't unliquidate meaning once fixed, on the other hand, is it descriptively accurate for our actual practices? If not, accurate for how we've dealt with problematic yet fixed prior constitutional sediments, why would we view it as normatively desirable standing on its own? My basic point then, just to wrap up, is that to the extent liquidation is a pragmatically justified extension or adjustment to originalism, I see it as giving rise to some grave questions about its normative underpinnings, ones that in some ways make it perhaps less desirable than either a pure search for original meaning or, on the other hand, a living constitutionalism. And I will stop there. Thank you.
All right. Well, thank you so much, Professor Milligan. So I have a question here. To what extent would you say that constitutional liquidation may or may not enable compromise? And anyone is welcome to respond.
I'm sorry, I just didn't hear the question.
To what extent do you think that constitutional liquidation may or may not enable compromise?
I don't know if it enables compromise so much as it's evidence of a compromise having been formed. I mean, I think liquidation is supposed to apply only where you're in the space of textual indeterminacy. And when you're in that space of indeterminacy, you can have credible views on either side of the debate. And I think when liquidation, the idea that a provision has liquidated is the idea that one side in the debate has folded and has accepted the settlement against what its preferences would be. So I'm not sure if it enables compromise so much as it evidences a compromise that has happened, which then allows for further development of the law in new and hard cases.
I guess I would add just, I agree with that. I think it also just attempts to kind of normatively bless and give some kind of more compelling justification for that sort of compromise that doesn't look like pure realpolitik, kind of accepting where the chips have fallen. I think it's also a compromise of sorts with the lived realities of text, right? That text runs out and original public meaning runs out. That's my sense of it.
Yeah, I'm not sure I have too much to add to the two responses.
All right. And so another question I have is, what would you say that the guardrails of liquidation should be, and how far out should it extend? I know we're going to have some different perspectives on this, but I'm curious to hear from all sides.
I think some of them have already been said, that you don't get into liquidation until the text is indeterminate. If you're in an area where the text is clear, it controls. If you have practice that is contrary to the plain text, it is wrong. And I think, as Caleb Nelson has written, one of the traditional exceptions to stare decisis is when the decision is manifestly erroneous, which is not the kind of erroneous that would be, if you have a liquidation case where there's plausible views on either side, the settlement, whichever way it goes, is not necessarily manifestly erroneous. But when you have something that goes against the plain text, I think it's manifestly erroneous. And so, this sort of, and as I said with the expoundment more broadly, not just with liquidation, expoundment is the idea, or what Randy Barnett would call construction, is the idea that you will have some natural evolution as legal rules and legal principles get adjudicated in specific cases over time. Again, the framers of the law of defamation had no knowledge of YouTube. That comes in later, and old principles have to be applied to new cases. I think one area where I disagree with some of the scholars in this field is the suggestion that maybe rights and structure are different and that liquidation should apply to structure but not rights. I think this kind of duality of rights and structure is maybe an unfortunate product of how we teach law in academic institutions. It's, a little like teaching, when we teach crime, I teach criminal law. When we teach crime, we teach mens rea and actus rea separately. But I think, as Gabe Menlo has argued correctly, I think, an action is really an indivisible unit of mens rea and actus reus. Just like just like you can't separate the molecule. You can separate water into hydrogen and oxygen, but hydrogen and oxygen looked at individually don't really give you the what water is. And I think action is kind of that way. And I think it's dangerous to separate rights and structure and say these are fundamentally different things. Some rights have structural implications. The right to vote is that way. The right to vote is both a personal right and is something that is structural to our system of government. The jury is that way, and the right to a jury trial. I think the Second Amendment is that way. It is both a personal right, but it is also a structural provision about how we divide military power in society between professional forces and the citizenry, and how that equilibrates the coercive authority of government. So I think it's a mistake to view rights and structure as entirely separate things. Rights and structure are often blended, and I think liquidation can apply to both.
Perhaps my prepared remarks suggested I don't see a lot of guardrails in the concept of liquidation. I mean, I hear and accept kind of the premises of the theory about, it's limited to indeterminacy, and it makes sense. But I think it actually tends to leave a lot of indeterminacy itself and kind of makes opaque some political choices that are necessarily made, both in kind of determining that we should follow the practice of accepting liquidation and as a theory of kind of how constitutional meaning is made. And then choices about when we find that meaning to be effectively fixed, at what point in time, and what kinds of evidence we take to be authoritative there. So to me, part of the problem is kind of the fuzzy edges that it kind of allows and embraces.
I guess I don't have, a date fixed, if that's what the question was looking for, that, practices that emerge after a particular date, after the Constitution's adopted, will somehow be out of bounds, and everything before that is within bounds. But I think that, and this might be somewhat responsive to some of the concerns Professor Milligan has raised, to the extent there's fuzziness with respect to this methodology, there just is fuzziness with respect to every methodology. And so it's relative in that sense. And I think that the methodology, and one might say, comparable issues, for example, arise when we're trying to interpret statutes or contracts in not politically salient circumstances, and we're dealing with an ambiguous provision. I mean, the optimal way of dealing that would be if the provision was not ambiguous, and we could just interpret it and say, all right, everybody agrees, this is exactly what it means. But there are these methodological approaches that have developed in those areas involving, and I know there are complications here, so hopefully the contract professors in the room don't call me on this, but involving resort to like parole evidence or resort to course of conduct, and I think as perhaps like as a real fallback in that area, you would say perhaps involving resort to like pragmatic considerations, like what is a sound interpretation of the contract, what makes sense of what the parties were trying to do, what was the spirit of the contract, what were they aiming at. And so that cluster of different considerations exists in all legal interpretation, and maybe one of the ways in which we're parting ways is in how we would prioritize the different considerations. And in that respect, I guess the question that's I think of is we do have mechanisms in these other areas, and it shouldn't be surprising that in the area of constitutional interpretation, trying to understand what the Constitution means, the mechanisms are more or less roughly the same. And that's not fully responsive to some of the other points that you had made a little bit earlier about the social practices and how they might have been different in various ways, which I take the point at the time the Constitution's adopted. And I wonder if it would be responsive to that concern to say, well, could there be, is there a difference between ascertaining meaning and then after that just debating, well, do we like the Constitution? I mean, that would be in some ways like what your set of criticisms were aiming at. And the issue sweeps more broadly than the Constitution, because there are a whole bunch of statutes which remain on the books that are adopted during that era. I mean, for example, the Sherman Act, or I don't know, we can pick a whole bunch, all the New Deal acts. They're all adopted during that era, and the question is, what do they mean on the one hand, and then were there some aspects of the polity that adopted them that we think, well, it's great that we've in fact changed our system of government and the way in which society is organized so that that's no longer part of it. So those are some thoughts that I had, both maybe on the question and also to engage with some of the earlier conversation.
All right, now it's time for audience questions. So I'd like to start off with Connor.
Do you want to talk about the bank?
So I'm curious to hear what others think about this, and I suppose one response, this might be not unsatisfying, is that perhaps it turns in a way on what you mean by departmentalism as well, because there may be different views on what that term even means. I suppose the mainstream position, and again I invite correction, would be that at a minimum, the Supreme Court, when it announces some sort of decision with respect to the parties that are before it, that sort of is binding with respect to the parties before it. And the departmentalist critique would say, well, we could nevertheless, in some other case involving other parties, apply a different constitutional principle, because the Supreme Court only has that more limited authority to bind the parties before it. And this is famously associated with people like President Lincoln's speaking on Dred Scott and other such cases. So I think that if the question is, do you have to embrace? You could have like a broader. You'd have to embrace at a minimum the idea that political actors can speak to constitutional meaning, and that gets given some weight when we perhaps are addressing the same constitutional question later on. And if that is wrapped up with the notion of departmentalism, then I guess you have to embrace departmentalism. But I think that you could have a more limited notion of what departmentalism means, and then this is an unrelated concept. Well, I shouldn't say unrelated. I should say related but distinct concept.
Strauss.
So I like the way I find the concept of distinction somewhat communicative. So really I'm wondering, is it meant to be, so you were Leider, you were describing it as being on the construction side, the interpretation construction side. But if that's the case, then it trades on a lot of the sense that what it's doing is semantic. The sense that what it's doing is, all we have a meaning of an unclear
I mean, I have to give more thought to this. I don't think I accept the rigid separation between interpretation and construction that Randy does. I think they're entwined. And so I haven't given a ton of thought to that, but I think they're related, and I think they're related in this sense. Law, a lot of law is teleological. It aims at some end, and the rights especially aim at some end. There's some practical problem that someone had, or that a community had, and they established a right to solve the practical problem. And I think at some level you're dealing with the linguistic indeterminacy. But to resolve that indeterminacy, I don't think you're just picking an answer as a matter of convention. I mean, maybe you could be doing that in some cases. But I think at some level, you're trying to figure out the best answer that serves the ends of the provision that are under consideration. And I think the debate that you have around that is a debate over what instrumentalities serve those ends, and there are better and worse answers to that question. And so I think part of what you're doing is resolving the linguistic indeterminacy. Part of what you're doing is implementation, but you're doing it in a realm in which you are serving some sort of ends to do it.
We have any further questions? Quilla.
I mean, in a country of hundreds of millions of people, you're not going to get to near total consensus, and I don't have an exact percentage in mind. I think one of the things that Will Bode and Caleb Nelson point to, and even Joseph Story, he didn't use the phrase liquidation, but he had the same idea in mind, is that at least for most of the dissenters, they come to acquiesce in the decision. And so the consensus is the idea that to the extent there was an opposing view, the opposing view recognizes the other view as legitimate. Now what percentage that is, I don't know. I mean, I think the other thing to keep in mind as dissenting views exist over time is that there is some check on liquidation, that whatever the consensus is cannot be a manifestly erroneous interpretation of the text. And so in federal courts, not in state courts, but in federal courts, the Second Amendment until Heller was generally viewed as a collective right, for at least in the 20th century, not necessarily before that. And I think that sort of settlement in the federal courts was so manifestly erroneous to the text and to the original principles that no matter what the consensus was on it, it had no legitimate claim to be a proper interpretation of the amendment. So, I think you have those built-in checks, but whether it's 70-30, 80-20, that I don't know, and I'm not even sure it's susceptible to that sort of numerical reduction.
Yes, sir.
Just to follow up, I had a similar kind of question. Is liquidation in, the United States kind of situation where you're liquidating a meeting that leads to a political settlement goes back to political law. Then there's liquidation that removes the settlement from the political process. This is the history and
I mean, I think anytime you remove something from the political process, maybe there should be a presumption against doing it. And we have a lot of you have the kind of Thayerian approach that maybe judges shouldn't be defining something as unconstitutional unless it's clear and leaving, questionable decisions for the political branches. So I think there is a danger anytime you ossify something with judges, that maybe it should lean against ossification, particularly in close cases. I think I might have missed part of the question, but yeah, I don't know what you have.
Yeah, I think it could conceivably make sense to look for something a little bit, you might say more, when in fact you're removing something from the political process. Having said that, at the same time, it seems to me that there were, and this perhaps gets to Professor Milligan's points, like there were certain early practices that you might say were accepted parts of the political process. I don't know how accepted. I mean, there were dissenters, and we wouldn't want to, or at least I would hesitate before saying that liquidated the meaning. And early laws that come to mind, for example, the parts of the Alien and Sedition Acts, you might say nowadays are unconstitutional. There was a majority that adopted those statutes. Needless to say, they become the acts, but they're dissenters, and so precisely how to understand the notion that Congress enacted these statutes that we think today are unconstitutional, I guess I wouldn't say just because they were enacted that it liquidated the meaning, or because there was a majority that accepted that as the way to understand the Constitution that settled the meaning.
I found the question interesting, but I think, like Professor Leider, I might have missed the first part. Was the premise of the first part of the question that that liquidation keeps some things in the political process? Or sorry, what? No, it's a.
One of the examples of political process is the question of the Bank of the United States. Is this going to be something that we're going to allow the political process to debate and create? And Madison's original position is that seems to offer a necessary part of Congress, but over time, political parties go back and forth. It seems like both political parties accept this as a legitimate exercise of power. So Madison concedes the issue. He doesn't say he was wrong about the meaning of the Constitution, but in his letters he writes that that's now liquidated and he's going to be willing to sign into existence the Bank of the United States. So it was a question as to whether or not the political process would be allowed to do this, but liquidation through political negotiation leads Madison to the conclusion that I'm going to allow the political process to do it. A different form of liquidation would be constitutional liquidation, where over time, political decision-making, say on a state level, say state after state after state takes a particular position on the execution of something along those lines. There's political negotiation over time, and ultimately the Supreme Court decides that there's been enough political negotiation for us now to entrench, to consider this constitutional issue as having been liquidated by the people, and we've come to a decision to entrench the right against draft entrenchment, or something along those lines, and thus remove from the political process the opportunity to impose the death penalty in some cases.
I guess to me, I'm not seeing the difference in the two forms of entrenchment other than it's Madison ceding versus the court adopting it as a constitutional decision. But I think that happens in the case of the Bank of the United States too, though it's a permissive stance rather than you may, Congress, rather than a you may not in the form of the Eighth Amendment. But I do think it's very interesting, and it just raises my basic question, which is at what point do we want to remove things from the political process? And my stance would be we need a normative framework to do some work for us in deciding that, which is, I think, what your points also implied, though perhaps I'm projecting. And we may be
Can I add one quick thing? I remember the point I lost a moment ago, and I think there may be two different things at work in your question. One is liquidation in terms of how we decide indeterminacy. A second is when are we going to recognize new customary rights? And I think the idea of a customary right may require much more than the settlement of an indeterminacy. You know, traditionally, a common law, a customary right required showing a custom that was immemorially used. And maybe immemorially is a bit of an exaggeration, but, you know, I think what you're asking in the second example is when do new customs have the force and effect of law? And I think the standard for, in an unwritten common law jurisdiction of standards of customs having the force and effect of law is a much higher standard than resolving something that has, liquidating something that is indeterminate and could go one way or the other.
So you would resist using the term liquidation at all?
All right, I'd like to thank our panelists.
Thank you very much. We are going to be setting up lunch now, and it'll be ready to eat in a few minutes. Thank you.
Oh, yeah.
I mean, I think part of it is just the statutes, right?
And our next panel will begin at 11:45.
Though, as we know, statutes are actually very